Mr. Chairman and members of the committee, my name is Jim Perdue, Jr. I'm past president of the Texas Trial Lawyers Association, which means I am not president for perpetuity, which is good for me as a volunteer. Mr. Chairman, I sit on the Texas Supreme Court's Rules Advisory Committee in my individual capacity, not as president of the Texas Trial Lawyers Association. So if there's questions about what the Supreme Court Rules Advisory Committee is doing in the interim, which I have participated in, I want to be real clear for purposes of testimony today, that is an individual capacity, although I do have some information, because humorously in the Omnibus Bill 3774, one of the things that came from Judicial Council was the idea of a mandatory disclosure in creditor suits of exemptions. The Chief touched on this. In my individual capacity, I chair the Legislative Mandate Subcommittee, and I was the one who had to bring the stakeholders of the debtors bar and the creditors bar together for those forms which have now been issued. It was as if I was a chairman of a committee in the House and bringing stakeholders to the table who do not much care for each other. But that committee got that done. We got a report, and there are mandatory rules now. I think the creditors bar is the least happy with them, but that's as it is, that happens. And so, be it, those are actually in effect courtesy of 3774. As the chief said, I think they go in effect next month, if not last month. And so that the committee knows, the Texas Trial Lawyers Association doesn't do debt collection work unless it's on the judgment. And so that is not really my area of expertise, although I learned a ton about it the past year. One of the interesting things about this committee's job as oversight during an interim is it's the oversight not of a state agency, but of an independent branch of government and the judiciary. And I think everybody can agree, regardless of where you come to at the bench and the bar, the independence of the judiciary is a constitutional imperative for Texas and for the United States. And in that, then, there is rulemaking authority granted through the government code to the Texas Supreme Court that leads to rules of civil procedure. And the legislature has interacted with the court and that process at different times. The one thing I think that I'll start with then is remote proceedings. As the committee will remember, there was a lot of debate because we were in the times of COVID during past session about how to address the question of remote proceedings on a go-forward basis, because at some point in time we all recognize this pandemic has to become part of living. And I think that that's exactly where we are. And so the court has already addressed this. There is an ongoing process to address remote proceedings at the Texas Supreme Court. Fortunately, the stakeholders have been involved, and as the chief said, I think there is pretty much uniform feedback anecdotally and in the data from all sides of the bar that forcing remote jury trials, regardless of an objection of the party, is a bad idea. And there seems to be consensus around that. There's an ongoing debate in the rulemaking process, but that is something obviously part of this committee's oversight. And given the interest in the last legislative session, that I think would be worth reporting again and again so that the chair is aware of what's going and the committee is aware of what's going on in that. I think that the bar, again, both sides of the bar seems to have agreed that the process needs to acknowledge some right to object. Chairman Dutton asked the question, in a civil jury, to not force the parties to go to a jury proceeding remotely if there is an objection. And the rulemaking process then is designed to address, for the flexibility of the courts, of the wide variety, depending on the jurisdiction you're in and the nature of the hearing, to allow for remote proceedings even when we get past the emergency orders that we're working under. And it seems to be that that's exactly the process that's working through. And I think that, I hope, and I think it's worth monitoring, that rulemaking process will, at the end of the day, be somewhat consistent with the conceptualization that the chairman and Senator Hughes and we were working on in the omnibus bill that didn't become part of the legislation at the end of the day. But I think that's worth monitoring. That's certainly something we will be part of monitoring. I may be involved individually in the process, but not in this capacity. But it's worth, if there's more reporting needed, the chief obviously is ultimately the person that writes the rules, but we'll be participating in that for y'all to be monitoring. One of the other interesting aspects, anecdotally, but also in the data, is as the committee knows, as members of the House, this is a 254 county state that is as variable as any state in the nation. And so the problems that exist for Harris County as far as the logistics of delivering access to justice are very different than Grayson County, somewhat different even than Tarrant County, but obviously different when you see that half the counties in the state have less than 20,000 citizens. Those propositions and the data and the collection of that data are very different because we have a robust data system in Harris County, but it's just obviously very different. And we engage in that anecdotally. I tried to collect as much data from our local TLAs before coming here today. I think everybody recognizes that there is somewhat of a backlog in the civil system. The drill down in the data, Mr. Chairman, is that the backlog seems to be more grounded in the criminal system, which obviously I'm not here to address. That is a function of the constitutional right to confrontation, which has even slowed down arraignment processes and things like that. And so anecdotally, whether it be Harris County or down to the Valley, you'll find pockets of courts where you don't have civil district courts, criminal district courts, family courts. And those counties then look differently regarding the backlog than you would in a county that has not specialized, but district courts with specific jurisdiction to the various dockets, as opposed to a court like in Walker County, where I've been in trial, where they're running a criminal docket every morning, and then you start civil trial at 9:30 in the morning. Those are just different propositions, and I think the data as far as being collected from OCA is pretty robust on that, but you have to parse it out because, as Ms. Lavoie said, you have a collective backlog that is all cases, and when it comes to civil jurisprudence and the interim charge, the data is actually a little better on the civil side than on the criminal side. And anecdotally, I will report that on our behalf of our TLAs, that's what we're hearing is people are getting back to life, you're getting jury trials. In Harris County, an agreed continuance cannot be requested for more than 4 months in most courts. They want you back on a trial docket within 4 months. That tells you that the system is trying to get you teed up and moving along, even in the instances of an agreed continuance. Representative Smith asked the question, so I was going to answer it. One of the challenges we had with jury selection in Harris County, which was unique, is Hurricane Harvey flooded our jury assembly hall. So we literally did not have a physical structure to conduct jury assembly when the pandemic hit in March of 20. But to the credit of Harris County to get functional, and I think, quite frankly, the data would say better than perhaps Dallas or Travis or Bear, we took on a different facility, and as Representative Schofield knows, we're moving through the process there, which allowed at least that anecdotally to move things along. I think that as the committee drills into kind of the issues of the delivery of justice, both remotely and flexibility going forward to resolve any kind of backlog, and then the rights of access and still being able to conduct trials consistent with the Constitution. Even the report from the National Center of State Courts has recognized remote proceedings can add time. They actually take 34% longer than a normal hearing if it's conducted in person. They're drilling in to try to technologically bridge that. That's something that we obviously, along with pay raises, are always here to help with and be a resource to help on how we can get resources to make that system work to the best it can. As far as specific policy, the major legislation from the last session is now subject to court interpretation and implementation. And I think that it is literally just starting as of September 1st. And that is a story that only can be told anecdotally at this point. There's really nothing to say. Lastly, on judicial selection, since it was raised, as the committee knows, there was a constitutional amendment to move qualifications from 4 to 8 years of practice to be able to run for district court. We were in favor of that. We would support that, and we look forward to seeing judges that reach that mandate now because that constitutional amendment did pass as far as qualifications to sit on the bench for the district court level. So those are really all my remarks, Mr. Chairman. I'd be happy to answer any questions.
I don't mean to put you on the spot on another issue you didn't cover, but where is TTLA on jury exemptions?
Jury exemptions?
Yeah, on our current allowable jury exemptions in Texas, and going forward. The speaker asked us to look at this. I'm growing increasingly concerned about classes of Texas citizens that are exempt from jury service, maybe for good reason, but where do you have a stated policy on that?
We don't, Your Honor. I mean,
Your
Mr.
Honor,
Chairman,
don't comment
I've done that to you before. So I got called for jury duty literally 2 weeks ago, and as I recall, it's you're responsible in the home for a child under the age of 14, over the age of 70. And then perhaps the most controversial one tends to be the issue of the ability to read and speak English. And that is in, I believe, the rule. But there are others, and I'm not familiar with the specific concern. Certainly, if there is an issue, we would be more than willing to look at it, get engaged in the process, and kind of understand it, because those live in the government code.
Yeah, and we've seen proposed legislation in past sessions seeking to grow that with good cause, for firefighters, police officers. I think there's one about teachers, and I wonder if that's a good idea for us to grow that list or actually to scale it back.
So, when you get into occupations, that is, having tried a fair number of cases, there's more teachers in the summertime in a veneer than you'll see in September, October. Is that a good or bad thing? Does that make it less representative of the community that you're in? I don't know. First responders is a very different question. We are blessed in Texas with having a system that kind of does things its own way and doesn't get uniform with the United States in a lot of ways to deal with what Texas represents, which is very diverse, very different. And in that process, we allow, attorney jury selection, unlike some other jurisdictions in the country that look either more like the federal system or have no jury selection whatsoever. And it usually, that process, because the attorneys are involved and the court is involved as well on exemptions and conflicts, usually seems, in my experience, to work out. That's, again, a personal one, not a statement on behalf of the association.
Okay. Representative Schofield.
I have two questions about the remote procedures that that were foisted upon us during the pandemic. I kind of think at some point it was going to come anyway, but it was going to be a big fight about whether to do it or not. Now we just hit a button and started doing it. And so I have two questions. The first is, you mentioned data that I haven't seen stating that remote proceedings were actually taking longer than in-person proceedings. Can you all get us whatever study that was? I haven't seen that data.
I'll send this to you. I'll get it to Cassidy, and it can be circulated. This is a report from the National Center for State Courts. It was issued December of 21.
I just missed it.
And, well, it's interesting because it got submitted to the Rules Advisory Committee after the debate began on this remote proceedings task force. And it's an interesting work product in that Mr. Slayton moved from OCA, and you can see Mr. Slayton's fingers all over this because it's data that he essentially brought to the National Centers for State Courts. And that's where I was quoting from, and I'll get this to you.
To the extent that you've read it and I haven't, is it just based on technological problems and having trouble getting people online? Is that what they think is causing delays?
The methodology of the study was to interview 52 judges and to collect the data on their docket administration during the affected time. And the specific table identifies that, and again, this is across dockets, criminal, civil, family, that it comes up with essentially collected hearing times, and it comes to a cumulative, whether it be felony all the way down to CPS hearing, 34% longer. The takeaways in the executive summary then seem to be, yes, technology, a functionality. You'll get a user like my father who can't use Zoom, who's just not good on the technology. Somebody falls off because of bandwidth. And the chief touched on this, what they're calling the proposal of a technical bailiff, kind of a technology bailiff, to supplement and try to resolve those issues with the interest of decreasing that time.
So that aspect, to the extent that we're seeing the hearings or whatever take longer, to the extent that as time goes on and the technology gets better, that aspect at least, if that's what's causing delay, will go away. Any other aspect we have to deal with?
Well, They have, I would say, Representative Schofield, there seems to be kind of a root cause at the end where they get to kind of hearing length gets analyzed, and they then propose certain solutions. Are there specific hearings that shouldn't be held remotely because they involve the hearing of testimony and it's contested? And does that lengthen it? And then, for example, they say we've got to do something about decreasing judicial burnout from being on Zoom for 7 hours a day. So it's multifactorial. It's not purely technology, but it's an interesting read as for the proposition.
That's something I hadn't anticipated that we're going to have to look into. The thing I did anticipate, and you touched on it, and so did Chairman Dutton with his question, is jury trials. I'm sure when the first time somebody said, let's get a group of people together to vote on this, they were anticipating the vote. But very quickly, we realized that a jury is not just 12 people, it becomes a body. They get together in the back room, they influence each other, and that has become part of what we anticipate. And that's, sort of the 12 angry men concept, where we'll get together and influence each other, and then we'll come out as a body and with our decision. I'm very concerned that the technology that's going to drive us to do a lot of things remotely, maybe to save costs, maybe to save time, maybe for the convenience of parties and non-parties who don't have to travel a long way to the courthouse, is going to lead to the erosion of that function. And we've already seen some, and I forget if it was testimony we had in this committee or if it was just a judge who told me, but we've already had at least one juror where the juror's wife, who was a lawyer, was clearly sitting in the room with him. And you don't know, yes, they're not interacting with each other when we're on Zoom, but who the heck is with them, and who is interacting with them? And so that makes me very concerned. I'm absolutely opposed to having criminal trials on with remote juries if anybody objects. Certainly, the defendant should have an absolute right to, but I think we ought to be really careful going forward before we start to standardize and normalize the concept of a jury that's not in the room together.
Agreed.
And so that really wasn't a question, but it gives you the opportunity to comment on your views on it.
Hearings are one thing. Jury trials are a complete different animal.
But I do, I always, once I make my statement, I kind of flip the other way and say, well, I also don't want it to become, in a very rare situation like a pandemic, or we had floods in Harris County from time to time, that I don't want it to become a strategy point, or we're just going to object so we don't have to do this, as opposed to, your right to a trial. But at some point, if we carve away enough of the other things remotely, we'll have room for those jury trials when we get back to having them and start kicking them out, which was kind of one of my question to Ms. Lavoie. And again, that's not really a question, but this is one of those turning points in the history of jurisprudence, and I do not want us going to a point where we fundamentally change the nature of juries unless we all decide that's what we want to do.
Right. I agree.
I think the Anglo-American judicial tradition, reflected in both the 6th and 7th Amendments of the United States Constitution, recognizes that, to use a colloquialism, there's a secret sauce of having 12 people come together and deliberate. It's been around for a long time for a reason.
Now, I also I have talked to a lot of lawyers who have done a lot of remote depositions and things like that, and they're not having nearly the problems with them I anticipated, including referring to documents and all kinds of things that the technology is very good on. But with respect to trials, what is your experience and those of your fellow folks in TTLA regarding just the idea of being in the same room with a witness and sizing them up and looking in their eyes when they're testifying? Is that something that we're going to lose as we decide kind of over time it's doing things remotely has benefits?
So, as president of the association, I would tell you that our position is a contested evidentiary hearing that involves witnesses, trial or not trial, should be done in person. I just believe that is a tool to get to credibility and truth that should not be lost for expediency, and I think that is the position of the association. As an individual who serves on the Rules Advisory Committee, you get then a wide divergence of opinion regarding that. But interestingly, Representative, it seems like the practitioners all agree on the proposition you just stated. there's something about being able to confront somebody in person and have them have to answer questions with the human interaction that's involved that's an imperative.
Thank you. Appreciate it.
Thanks.
Thank you, Mr.
Any other
Chairman.
questions? Jim, thank you. Look forward to working with you.